Hello, good afternoon. My name is Jeff Vogt. I'm the Rule of Law Director for the Solidarity Center, which is a US based NGO that works with workers and trade unionists around the world. And I'm also the chair of the ILAW network, which is the International Lawyers Assisting Workers Network, which was formed in very late 2018 with the idea of bringing together kind of worker and union side labor lawyers around the world into a single global network. And I'll be happy at any point to talk to folks about that network in your questions and let you know how to join. But today I wanted to talk to you about the global governance of labor and its implications for workers worldwide, but obviously in particular for Africa. And this, of course, has a even greater salience now uh, with a pandemic, which we've been confronting for the last several months, and which has had a tremendous impact on global supply chains and, of course, the workers who are employed in those supply chains. Um, so let me just first kind of identify what are the problems. Um, so you know, from you're looking at this through the framework of a kind of corporate accountability and access to justice lens is the way I'm framing this presentation. And globally, what we see is that workers, at the national level, encounter substantial difficulties in accessing effective remedies when their rights are violated. And there are a lot of reasons for this. Obviously, there are deep-seated weaknesses in public institutions. There could be also, deep-seated antagonism towards workers and unions, as well as discriminatory norms and practices, which we see around the world that are, against certain groups of people based on their identities, which also deny workers access to justice. And in many cases, we see that this discrimination uh, manifests itself as an exclusion from effective legal protection, whether it's um, to push persons altogether into the informal economy by not recognizing their workers' work, or is to erect legal or institutional barriers to those people being able to access justice. And so we have these problems already, again, globally at the national level, but these become even more difficult when we're talking about the acts or missions of multinational enterprises whose decision making are having impacts on the entirety of global supply chains. And so it's not as if the MNEs who are benefiting from trade and investment in supply chains are passive about this, but are actually they're sourcing decisions and contractual protections do give rise to creating more opportunities for labor rights violations to occur. But these MNEs are often well beyond the reach of accountability of national institutions. Um, Still after decades of focus on this, responsibility of multinational enterprises still is governed largely by non-binding guidelines and a vast network of corporate codes of conduct and multi-stakeholder initiatives, which continue to show their ineffectiveness. So, on the kind of the international guidelines, obviously, I think we're maybe mostly familiar with the UN Guiding Principles on Business and Human Rights. This is kind of the premier, set of principles that were articulated by the UN a few years ago, now almost 10, and in which apportion kind of obligations and responsibilities of both of states and of corporations for their conduct and their impact on human rights globally. And these guiding principles do inform kind of the expectations of stakeholders and what responsible business should be doing in order to prevent or remedy human rights violations. Now, these principles have been enacted into the OECD guidelines for multinational enterprises, which similarly for the multinational enterprises based in OECD countries uh, and a few others, kind of set forth kind of expectations, and also creating a kind of a mediation and kind of non-binding dispute settlement mechanism. And then most recently, the ILO Tripartite Declaration on Principles Concerning Multinational Enterprises on Social Policy um, was an instrument from the early 70s that was refreshed in light of the UNGPs, but again, a non-binding set of principles. There has been an effort, of course, at the ILO to come up with a new and binding instruments that would set forth expectations about multinational enterprises and labor rights. This discussion started really in earnest in 2016, which again is decades too late. But due to stiff opposition by largely the employers group and some governments, it's been very difficult to make progress. And as of earlier this year, when there was the last in a series of experts meetings to discuss the way forward, it does seem like we are still quite a distance from being able to have effective global regulation for supply chains. At the same time, the UN Treaty on Business and Human Rights, which is a kind of a broader framework, again inspired by the UN Guiding Principles, is under negotiation. A new draft was just released last month, but it's still unclear in which direction this is going to head, and whether governments in the end will be sufficient for support for its adoption and ratification. At the same time, international financial institutions are continuing to promote incoherent policies, which tend to undermine worker rights and social protections, and act often in direct conflict with the research and legal obligations of ILO member states. But given all of these issues, there have been some rather important initiatives in recent years, which I think are interesting to take a look at and discuss, which will be the meat of this discussion, which do attempt to both hold companies liable for the acts of the company, subsidiaries, and business relationships in supply chains, or disincentivize their participation in these violations. And importantly, do provide a remedy. These are not by any means easy, or yeah, but I think these are definitely things that we should take a look at and see how we can improve upon them. So I just want to first actually start with a recent case of transnational bargaining, which I should put here. I think this is probably one of the more innovative things to happen in the last several years. Again, limiting these examples to Africa in particular, was an agreement in Lesotho in which trade unions, women's rights organizations, and international NGOs and trade unions came together and negotiated with Nian Singh, which is a large garment manufacturer in Lesotho and elsewhere in the world, and 3 US global brands, Levi Strauss, Children's Place, and Contour Brands, to negotiate a binding, legally binding agreement. And this agreement came out of the experience of workers, largely women workers, in factories in Lesotho, who are being exposed to severe and extensive sexual harassment and coercion by the supplier, with here the Niansing. And there were reports, dozens of reports of workers who have been, coerced by managers into sexual relationships in order to maintain their jobs, or or to not uh, be punished, or have better work schedules. Um, and this had been going on for quite some time. This is despite the fact that these global brands have codes of conduct and had conducted audits which failed, which prohibit this behavior, but nevertheless failed to identify and prevent this behavior from happening. Uh, so, on the basis of that investigation by the Worker Rights Consortium, uh, the kind of unions, NGOs, and the brands and the supplier Niansing sat down and negotiated agreements on the one hand with the manufacturer that does bind them to a code of conduct, which is very specifically driven towards sexual harassment in the work, sexual harassment and gender-based violence in the workplace, um, and also importantly has binding language around freedom of association, so that workers and trade unions are able to operate freely and without retaliation. Um, the brands have committed to, and the supplier to, funding a program which would include kind of independent kind of, well, training on the one hand, but also an independent complaints mechanism, a complaints and audit mechanism in Lesotho that is able to receive complaints, to conduct investigations on their own initiative, and that should there be a violation detected, that Nian Singh would take appropriate action under the agreement. And I think the important thing out of this, and which makes this truly binding, is that the three brands have agreed that if the the supplier, Nian Singh, fails to implement any of the remedies that are adopted at the level in Lesotho in the factories, that they would agree to begin withdrawing orders from those factories, which creates a significant economic incentive for Nian Singh to comply. So this agreement comes out of an experience that workers had in other examples with the Bangladesh Accord that came out of the factory collapse in Bangladesh in 2013. That was an agreement that was modeled around occupational safety and health, and similarly had these mechanisms whereby global brands took obligations around workplace remediation, investing in upgrading factories where the suppliers were unable to do so, and created an arbitration mechanism. So um, if the factories failed to comply, there's a way again for the brands to hold those factories accountable. Um, and a similar situation in Honduras with Fruit of the Loom, that one focusing more on freedom of association. So these uh, agreements that have been negotiated again with workers in the lead, and having a transnational character, that are really binding in a way that previous initiatives have not been. So I think this is something definitely worth further study. It is still in its early stages, um, so there's much still to do, but I think it is an interesting model that we're seeing. It itself comes after a couple of efforts in other countries, and I think we can expect to see this model being replicated in other countries, shifted to obviously address the specific harms that are being raised in those countries. Um, I'll also mention just briefly trade. We're seeing an increased use of trade mechanisms for the purposes of both corporate accountability and access to remedy. Um, since 2016, the U.S. Tariff Act has prohibited the importation of goods that are produced wholly or in part by forced labor or prison labor, and these goods can be prohibited from entry into the U.S., or they can actually be seized, and the importers can be actually criminally prosecuted. Um, Over the last few years, we've seen a number of examples where this tariff act has been used. Um, it's still largely used with regard to goods from China, but we have in the last, since 2019, seen a number of examples coming from other countries. Right now, there are active withhold release orders, which is kind of the notice from our customs agency to ports to not allow the entry of tobacco from Malawi, of gold from artisanal mines in the DRC, and artisanal rough cut diamonds from a particular diamond field, the Maranga diamond field in Zimbabwe. And there is currently an ongoing review on cocoa coming out of Cote d'Ivoire. So once a petition has been filed, uh, the customs will review the evidence, maybe seek additional information, and then make a determination as to whether there's sufficient evidence to withhold the goods at entry. The importer then can show that, in fact, that it has done its due diligence and can demonstrate that the goods that it is seeking to import are not made with forced or prison labor, and allow those goods to enter. And in a couple of cases, in the case of Malawi and the DRC, specific importers have presented due diligence plans to customs to allow them to continue to import these goods despite the withhold release order. Also, just this is so this does have a direct impact on the importers. Obviously, knowing that this law could prevent them from being able to import goods, and obviously then lose their investments. It is encouraging, slowly but surely encouraging importers to do more to ensure that their supply chains are not tainted by forced or prison labor. The question of remedy is still something that we are working directly with customs to try to resolve, so that we don't have a situation where workers are simply lose their jobs because of the imposition of a WRO, but there is a way, in fact, in which to ensure that to the extent they have been unpaid or other elements of forced labor, that there is a way to make sure that those workers are working in free labor and are being paid for that labor. So more to do there. There are also the generalized system of preferences, which I think many are probably aware of. The US has just recently opened up a review on the trade preferences for Eritrea and Zimbabwe. Eritrea over forced labor, and Zimbabwe over freedom of association. And I just mentioned the UK has and Canada have a similar legislation like the Tariff Act. And let me just go to this. I think finally, given the time, just also wanted to point out some interesting litigation, which is also trying to hold transnational corporations accountable for what is happening in their supply chains. Uh, some successfully, some unsuccessfully, but I think they're very interesting to take a look at and figure out again what is how these cases, to the extent unsuccessful, could be done differently. Right now, before the U.S. Supreme Court, is a case Nestle versus John Doe. This is a case filed almost 15 years ago, in which child agricultural workers from Mali were brought into Cote d'Ivoire to work on a cocoa plantation. They alleged, severe mistreatment, kind of beatings, forced to work long hours without pay on farms that were sourcing to Nestle. Nestle, of course, claims it has no knowledge, but plaintiffs are alleging that Nestle knew the plantations used forced labor and that Nestle continued to support these plantations and source from them, even in light of this knowledge. The case is before the U.S. Supreme Court now, not actually on the merits of the case. It's on the question as to whether any U.S. corporation can be held legally liable under the Alien Tort Statute, which is a law that goes back to 1789, the first Judiciary Act, and allows a foreign defendant to file a claim in federal court alleging a violation of the law of nations, which would be customary international law. So we expect probably early next year to know whether the Supreme Court is going to throw the idea of corporate liability completely out the window. If it does not, then this case may go forward and being remanded back for further proceedings. There was another case under the Alien Tort Statute some years ago against the Firestone Rubber Company in Liberia, again, also around child laborers. In this case, the allegation was that the workers were being paid so low, and it was known that because of the wages that are being paid, the families were bringing their children along with him in order to meet production quotas. And Firestone, having set up this plantation in the early 1920s, basically had total control over what was happening on the plantations, and was well aware of this dynamic. In the end, the case was dismissed on appeal in 2011. But I think it is, again, a very interesting use of the Alien Tort Statute. In this one, because it was not, one of the reasons for its dismissal was that Firestone was not directly hiring the children, but it was because of its practices of in payment to the parents, and kind of essentially forcing them to bring on child labor in order to meet quotas, that was insufficient in the view of the court to assign liability. I think a really interesting one out of Canada, Nevson Resources, opened up comes out of Eritrea. They're a Canadian mining company was sued for violations of customary international law, being forced labor, because the plaintiffs have been conscripted to work on a mine between 2008 and 2012 under the government's national service program, where they've forced workers to work on major projects, obviously without their consent. The workers pled in Canada that this is a violation of customary international law, of forced labor, slavery, cruel, inhumane, and degrading treatment. And the court said, well, actually, yes, customary international law is incorporated into the common law of Canada, and the suit in a British Columbian court can proceed because the court has jurisdiction. And once this decision was made, this quickly led to a settlement in October of 2020. So a very interesting case in Canada, with obviously implications for supply chains in Africa. And recently there was a case that is in early stages, going back to Malawi and tobacco, where plaintiffs allege that British American Tobacco was unjustly enriched by the unpaid child labor in the tobacco fields in Malawi. So as of the last update, there has been a kind of pre-letter that has been sent to the company, threatening action, and the firm is now working to put the case together. And finally, these are common law countries. Now looking at France, this is an environmental case, but it has implications also for labor. A number of NGOs had filed a claim in 2019 against Total because of its insufficient environmental oversight plan, and the fact that many people had been displaced and land seized by Total in Uganda. This claim has taken interesting procedural turns. The plaintiffs brought this case before a kind of common tribunal, and the court found that instead, because this was a dispute over a vigilance plan, which is falls more in the area of commercial law, then this actually belongs before a commercial court rather than a common court. And this case was argued actually just a couple of weeks ago before the Versailles Court of Appeals as to which court has the appropriate jurisdiction, with the concern being that if this goes before a commercial court, it's going to obviously lean heavily towards the multinational enterprise, and that commercial courts are really not in a place to assess human rights claims. And another one I think is not related to Africa, but rather South Asia. But again, an interesting use of law to try to bring a remedy for workers in supply chains, that survivors and relatives of victims in a factory fire in Pakistan, in Karachi, some years ago, brought a lawsuit against a German garment company, Kick, which is the factory's main customer, and in fact, they were the vast majority of the goods went to Kick. Kick had a long-term relationship with this factory, and I think was alleged that they were well aware of the occupational safety and health issues at the time. The regional court in Dortmund unfortunately dismissed the lawsuit because it was time barred. The statute of limitations had run out. They applied the statute of limitations of Pakistan. There had actually been some back and forth with the company as to whether they had waived or were going to waive the statute of limitations. In the end, the court found that it was time barred, and the case has not been appealed. So in the end, the court did not address the merits of the claims of the liability, but I think it does still open up the possibility if the statute of limitations does not run, that this could be a claim worth pursuing in a German court. So I will end it there. I want to thank you for your time and attention. I think these are some interesting developments in international law as they relate to worker rights and global supply chains, and I'll be more than happy to take any questions or provide further information. So thank you very much for your attention.